call the fourth case on this morning's docket, case number 112897 and 119709 in the matter of Sam Kepfield.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Mr. Chief Justice, I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving Sam Kepfield, an attorney who was admitted to the bar in 1989. The matter before the court involves 2 disciplinary complaints filed against Mr. Kepfield while he was on probation, DA 12-657 and DA 12-710. The 2 complaints were heard before a panel on May 8, 2018. In DA 12-657, Mr. Kepfield was appointed to represent ES in appealing the denial of ES's post-conviction motion. Mr. Kepfield filed an appellate brief in the Court of Appeals on behalf of ES. The matter was set on the Court of Appeals August 2016 summary calendar docket. On August 16, 2016, while the appeal was still pending, ES filed a pro se motion to have Mr. Kepfield removed as appellate counsel. Mr. Kepfield received a copy of the motion, but did not file a motion to withdraw or take any other actions to address ES's pro se motion. On August 26, 2016, the Court of Appeals denied ES's motion to have Mr. Kepfield removed and issued its opinion affirming the denial of ES's post-conviction motion. Because the Court of Appeals denied ES's motion to have Mr. Kepfield removed, Mr. Kepfield remained counsel of record and, in turn, remained responsible for ensuring that ES's appellate rights were preserved. Prior to the deadline for filing a petition for review, ES attempted to file a pro se petition for review, but the appellate clerk's office, based on Supreme Court Rule 5.01d, did not accept the petition for filing because Mr. Kepfield was still counsel of record for ES. Despite receiving a copy of ES's pro se filing, which would indicate that ES wanted to appeal the Court of Appeals' decision, Mr. Kepfield did not file a petition for review for ES, resulting in ES losing his ability to appeal the Court of Appeals' decision. Based on these facts, the hearing panel concluded that Mr. Kepfield violated 1.3 diligence and 1.16 termination of representation. The second complaint, DA 12-710, involves Mr. Kepfield's representation of EM in a DUI case. In September of 2014, EM advanced funds to Mr. Kepfield to begin the representation. Mr. Kepfield failed to put this money into a trust account because, at that time, Mr. Kepfield did not have a trust account. Ultimately, EM filed a complaint with the Disciplinary Administrator's Office in December of 2016. During an interview with the investigator, Mr. Kepfield told the investigator that he deposited EM's advance payment into his trust account. Subsequently, Mr. Kepfield failed to respond to the investigator's request for him to produce records of the non-existent trust account. In August of 2017, the Disciplinary Administrator's Office sent a letter to Mr. Kepfield requesting that he provide the office with his trust account records. In response to this request, Mr. Kepfield finally admitted that he had closed his trust account in 2011 and did not reopen one until August of 2017. Based on these facts, the panel concluded that Mr. Kepfield violated 1.15a, safeguarding client property, 8.1a, making a false statement of material fact in connection with a disciplinary matter, and 8.4c, engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. The 2 complaints against Mr. Kepfield were filed with the Disciplinary Administrator's Office after this court in April 2015 placed Mr. Kepfield on probation for 3 years for conduct that violated Rules 1.2, scope of representation, 1.3, diligence, 1.4a, communication, and 1.16d, terminating representation. Accordingly, the Disciplinary Administrator's Office filed motions to revoke Mr. Kepfield's probation with this court and with the chairman of the Kansas Board for the Discipline of Attorneys. The matter was then consolidated with the 2 complaints and heard by the panel on May 8, 2018. At the panel hearing, the disciplinary administrator's office first recommended that Mr. Kepfield's probation be revoked based on his violation of paragraph 20 of his probation plan, stating that he would not violate any of the Kansas rules of professional conduct, and if he did so, he would immediately report any violations to a probation supervisor and to the disciplinary administrator's office. Based on Mr. Kepfield's prior discipline and the fact that he committed new rule violations while on probation, the disciplinary administrator's office recommended that Mr. Kepfield be disbarred. Mr. Kepfield asked that he remain on probation for another 3 years. Ultimately, the panel concluded that the rule violations in DA 12-657 and DA 12-710 constitute a violation of Mr. Kepfield's probation. The hearing panel recommended that Mr. Kepfield be suspended for 3 years and that, after serving 6 months of that suspension, be placed on probation for 3 years. After the hearing panel's report was filed with this court, Mr. Kepfield filed a notice that he was not taking exceptions to the report. Accordingly, under Supreme Court Rule 212C, the panel's findings are deemed admitted. At this time, the disciplinary administrator's office is recommending that Mr. Kepfield be indefinitely suspended. We're recommending this sanction as opposed to disbarment because the conduct and rule violations that were found by the panel are not as severe as the conduct that was alleged in the formal complaint and considered by the disciplinary administrator's office when making its recommendation of disbarment at the hearing. The panel ultimately did not find that Mr. Kepfield's conduct in DA 12-657, the complaint involving ES, violated either Rule 8.1, failing to correct a misapprehension in connection with a disciplinary matter, or Rule 8.4C, conduct involving dishonesty, fraud, deceit, or misrepresentation. Furthermore, the panel did not find that Mr. Kepfield's conduct in DA 12-710 violated either Rule 3.1, meritorious claims or contentions, or 3.3, candor to the tribunal. That is not to say that the conduct that the panel did find that Mr. Kepfield engaged in was not serious. The panel found that while Mr. Kepfield was on probation, he lied to an investigator about placing client funds in a non-existent trust account. This conduct, when considered with Mr. Kepfield's prior discipline, should warrant Mr. Kepfield being indefinitely suspended. Contrary to the panel, the disciplinary administrator's office does not believe it would be appropriate to place Mr. Kepfield on probation, considering his disciplinary history, the fact that he's already been given a chance at probation and committed new rule violations while on probation, which included 8.1 and 8.4C, which implicate dishonest conduct. The court has indicated in numerous opinions that it is reluctant to grant probation where the misconduct at issue involves dishonesty. In support of that proposition, I would cite the court's decisions in Re Stockwell, 296 Can 860 at 868, 2013 case, and the court's decision in Re Baker, 296 Can 696 at 709, another 2013 case. In conclusion, I recommend that the court indefinitely suspend Mr. Kepfield's law license. Unless the court has any questions for me, I would waive the remainder of my time and address the court again during rebuttal.
I have just one, and this may not be something you can answer because you weren't the officer, you weren't the attorney handling
My
the
colleague
case.
Penny Moylan
Ms. Moylan, right.
litigated the case down below.
There was a finding by the panel that the results that Mr. Kepfield obtained for ES and EM were good results, and I was curious about that. Can you?
I think that was the dissenting panel member.
No?
It was not?
No. There was one finding that it wasn't, but it was, and again, if you can't answer it, that's fine. I was just curious about it. And
Okay. I will review the hearing panel report and address that during rebuttal, but I thought it was the dissenting hearing panel member who found that his conduct towards ES resulted in a benefit to ES, and that was what the dissenting member held.
Mm-hmm. All right, thank you.
Counsel, what are you asking for is the start date for the indefinite suspension when the decision is released?
When the decision is released.
Okay. Any more questions? Thank you, counsel.
Thank you.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. To be clear, we are asking that the respondent remain on probation, that the probation be extended 3 years, and that he remain practicing as a lawyer in the Sedgwick County Public Defender's Office. Since this hearing in July of this year, he has sought and been hired as one of the senior attorneys in the Sedgwick County Public Defender's Office, which is where he should have been for most of his career. When he first started out as a lawyer, he was in legal services for prisoners, and for 5 or 6 years, not one problem. Now that he's in the Public Defender's Office, where he has supervisors, where he has secretaries, where he has paralegals, where he has a social worker, we don't anticipate any problems. Some people are not cut out to practice law in the private sector. Maybe many of us aren't able to do it. He, for 16 years, labors in Hutchinson County doing a criminal practice, doing domestic work and other work, and he has no secretaries, no law clerks. He's got to do all of his own keyboarding. He has to do everything by himself, and he has to have the organizational skills that require him to run an office. And frankly, Mr. Kepfield does not have them. He's very bright. He does a good job in the courtroom. He does a good job on writing his appeals, but he's atrocious in running an office, in paying himself, in paying taxes and everything else. There are many, many lawyers in this state that practice by themselves. There are many who don't have the ability to hire secretaries, and they're not before the court. But you combine these problems that my client has along with the depression, and it's a recipe for failure, and he failed. He was given a chance to be on probation. He had a very good supervisor in Ms. McKinnon in Hutchinson. But even that was not enough to corral him, to keep him in order to understand how to run a practice. We're now asking, and Mark Orr, who's the head of the office, the Public Defender's Office, is going to be a supervisor. Now he has everything that he needs where he can just go to the office at 7:30 or 8 o'clock, practice criminal law, work out of the noontime, go back from 1 o'clock to 5:30 and work, and then go home. Visit his clients at jail in the evenings and on the weekends, and just be a lawyer, not be a business person, not take care of a trust account, not take care of a business account. That's what he needs. I blame myself for a couple of years ago when we were up here for not grabbing him by the scruff of the neck and saying, you shouldn't be in private practice. You're a miserable failure at the business side of this. You need to apply to the Hutchinson Public Defender's Office, to Sedgwick, to Garden City. He finally took that on himself last May or June and is in that office and is doing very well. That's what we're asking. With your permission, my client would like to address you.
Before he approaches counsel, can you address, in light of what you've said, the charge and violation found for lying to an investigator?
He got scared. He got scared to death. They said, did you put that money in the trust account? He got scared and he said, it's in my trust account. He didn't have a trust account. He does what all of my criminal clients used to do and some of my lawyers. They got scared, and instead of simply saying, I don't have one, what I was doing with the money was I would take the money I would get and I would put it, when it was cash, I'd put it in a strong box at a bank. He didn't tell him. There's no excuse for him. He feels very badly about it.
So it's not attributable to his lack of business skills that he was scared.
But he was scared, and depressed people act differently than you and I do. I don't think there's any doubt about that.
Mr. Ambrosio, to follow up on the Chief's question, as I understand from reading the record at the hearing, he indicated he didn't even know that he needed a trust account until you told him.
That's correct.
However, he misled the representative earlier, supposedly before he even knew he had one. So where does the fear factor come in?
I can't explain why people why they get fearful.
But he said he didn't know he needed a trust account, and you're saying that he was scared.
I think it's a combination of both things. He didn't know and he was fearful. I think he said at the hearing, I may be wrong, he heard one of my lectures once into CLE, and then he realized he needed a trust account.
But that was after he talked to the
Absolutely.
investigator.
There's no excuse for it. I'm not going to be so crazy to come up here and say he was, forgive him for everything. He understands he did wrong, and that's why I like him in the Sedgwick County Attorney's Office. There's never an excuse for lying. We learned that back in the second grade, if not before that.
Thank you.
Do we have any further questions of counsel? All right, we'll hear from your client.
Thank you, Your Honor. Sam, Mr. Cutfield.
Good morning. Despite everything that Mr. Ambrosio said, it's really kind of hard for me to voice just the overwhelming sense of utter failure that I feel right now. Obviously, I failed my clients. Most importantly, that I wouldn't be here if I hadn't. I failed those folks who had supported me last time around. That's why I didn't have anyone to write any letters, because I can't ask them to, jump on a sinking ship. I failed Mr. Ambrosio, who put faith in me, and I failed you. 4 years ago, you gave me a chance that maybe I didn't deserve, and I did my absolute best, but I failed, and I can't change what I did. As far as the trust account, I think John's right. I mean, I got stupid and I panicked. It's what a lot of my clients do. There is no excuse for it. I'm not going to stand up here and rationalize it. That is something that we weren't taught. I mean, just throwing a rule book at somebody and saying, here, learn this and figure it out, isn't enough when you're, a single practitioner trying to, meeting yourself coming and going, as John used to say. I mean, that's not an excuse, that's an explanation. But I didn't get into this to get rich. I never liked handling the money. I didn't do this to support a lifestyle. And I got into it in a tradition of public service that my family has. I shouldn't have made those statements to the investigator. They were wrong, and frankly, whatever you decide to do to me, I think you'll probably have a good reason for it. Does it mean I shouldn't be allowed to practice law? Does it mean I'm a bad lawyer? I don't know. That's for you to decide. And as far as what happened, I can't change that. I mean, God knows I wish I could. But I have, I guess, taken some measures to make sure it doesn't happen again. I mean, the day after the panel hearing in May, I sat down with Ms. McKinnon and I said, gee, maybe I shouldn't be doing this. Maybe I should find another job. I read a lot of books, what to do with a law degree, how to use a law degree without practicing law. I still have them. I may need them again. But she said that, well, the Sedgwick County Public Defender has an opening for 6 experienced attorneys. Why don't you give them a call? So I guess that day I sent an email to Mark Orr, who I've known for years. He used to work at Legal Services for Prisoners before I did. I've seen him at COEs and known him for 20 years. Sent him an email, sent him a resume. I got an interview, and I at the interview I told him, I'm damaged goods. I don't even know if I'm going to have a license in 6 months. I will understand if you don't want to hire me. I'll find something else. But much to my surprise, they put some faith in me. They hired me, and I think I'm in a good place. I have this thing called support staff, which I didn't have before. I have, if I don't have to do everything, I don't have to, if I need a guy who's got an evaluation, I don't have to set it up. I give the file to our social worker. If there's a drug evaluation, I give the file to our records person. I get there in the morning, there's usually a couple new files on my chair. I open them up, write a letter to the client, make an appointment to go see them, and do what I need to do. I'm a lawyer. I'm not running an office. I'm not having to be in 3 counties in one day. I don't have to drive to Pawnee County, to Clay County, to Geary County again. I don't have to handle money. I don't want to. I don't have to schedule. That's done for me. They just tell me where to be and when, and I'm usually there 98% of the time. And I guess they hired me because they needed folks there who with some experience, and they've hired the last couple of years. They hired a lot of folks who were younger, out of law school, and I've been kind of using my experience to help them, you know, how to handle cases, what to do. And the other thing I think I can do is I can tell them what not to do, so they don't have to stand up here someday. If anything good comes out of this mess that I've made for myself, that might be it. If I can save somebody from, you know, having to pay John a few $1,000s and, you know, to have their name published in the Kansas reports, maybe it's worth it. I don't have to do what got me in trouble. I don't have to do appeals. I don't do post-conviction. I don't do administrative stuff. I don't handle money. I don't run an office. I'm just a lawyer, which is what I've always wanted to be. And you can do whatever you want. And if you think I shouldn't be a lawyer anymore, that's your decision. I don't think I'll argue with it too much. But whatever quibbles I might have with the report, with anything else in there, you know, ultimately it's irrelevant because I have to take responsibility for my actions, and I do. I would just hope that you agree that I can't make a promise to you. I'm not stupid enough to make a promise to you that I'll never have another problem again. But I think the chances of it are greatly reduced, and that I can make it through the next 3 years or however long you see fit. I can make it through, get all of this finally behind me, and focus completely on my clients. I mean, I regret that, you know, all the good I've done over the years. I mean, I've appeared before you numerous times in the Court of Appeals. It's been great. I've enjoyed it. It's been a real experience, great learning experience, but I'm not doing it anymore. I've left that behind. But all the good that I've done, I destroyed it. Okay? I destroyed it. People aren't going to look at me the same no matter what you do. You know, I've got no one but myself to blame. If you have any questions, I'd be more than happy to answer them to my best of my ability.
As we discuss what sort of discipline to impose, I think this is relevant.
Don't lean on
I'm sorry, what, I didn't hear. What is?
I'm formulating my question
Okay,
right now.
all right, I'm sorry. What is relevant?
In terms of lying to the investigator, how did that come to light? In other words, did you realize what you had done and then you told Stan Hazlett's office, I lied, or were you confronted with the lie and then you admitted it? Do you remember?
I didn't bring the file with me. I think I may have just, you know, in my mind, and this isn't an excuse, okay? This is not an excuse. This is an explanation. You know, I had considered that the money was safe. I wasn't putting it in one pocket and spending it. I mean, it was safe. In fact, it's harder to get to it where it was than it is in an account with electronic banking now. But I kept it there, and it was safe, and, you know, drawn as needed. I don't have an excuse for it.
But my question is, after you discussed this or gave your answer to the investigator, how was this lie proven? Did you come forward and say, I did this, or were you confronted with it?
I didn't know not to do it.
You what?
I didn't admit it. I was
Confronted with it?
No, he did not own it to it, Your Honor, I think is what he said.
no, and I didn't even think that was going to be a part of the inquiry. It just kind of came out of nowhere. I mean, this Mr. Martinez wasn't saying EM wasn't saying anything about the money. It just sort of sprung up on me, and
That's not what he's asking. He wants to know how you were confronted by
Yeah,
this
I
one.
mean, I was. Yeah, okay, fine. I didn't, but I just as John said, and my clients do this. You know, you're already under a microscope. You're fearful. I mean, I was fearful. You know, they're already investigating me. I'm already on probation. Somebody's there sitting asking me questions. I just didn't think. I panicked. I got stupid. Okay, there's no excuse for it, and
I understand that.
I'd say
Maybe your counsel can help
He
with what I'm asking.
never fessed up to
No.
answer your question, Your Honor. He did not.
No,
right, thank you.
I didn't, and I should have. But again, I was just, if I hadn't already been on probation, I would have. But I was just being squeezed. I was stupid. I was whatever you want to tell me, whatever you want to say about me, I'll admit it. Okay.
Do we have any further presentation from either of you?
We do not.
Are there any further questions?
Chief, I just
Counsel
have
here,
one
yes.
more. Mr. Keffel, thank you for your comments. If you could elaborate on something you testified to, and you said while you admit failing in the two cases, you stated that there was little practical chance of ES or EM succeeding. Could you elaborate on that?
Well, I think there was more. I think I was answering a question. That's not relevant. I mean, it doesn't really matter ultimately whether they had a chance of succeeding or not. I mean, the facts are in the administrative appeal. Well, in the criminal appeal on EM, we lost a trial, but the Court of Appeals later reversed, saying,
But you didn't. You filed the notice of appeal, but you didn't handle the appeal. Is that correct?
That's correct.
That's right. That's right. But they said remand and say grant the suppression motion, and then the administrative one. It was the question was whether it was the notice was late or not. It was, but I thought, well, heck, maybe I can do an Ortiz exception. I mean, they do it in other things. The worst the court can say is no. So I did that. I didn't know whether it would succeed or not. As far as Mr. Spear goes, I mean, the petition for I did the brief for the Court of Appeals, and then the grounds. Well, the Court of Appeals rendered an opinion in 9 days.
That was a Jessica's Law conviction.
No, it was a Jessica's Law case. Convicted on 10 counts. Court of Appeals threw out 6. But I can't say for sure what this court would have done had that petition come before it. I don't know.
I appreciate that.
But
I think you've answered the presenter's question.
yeah,
I just wanted that answer clarified. So thank you.
is there anything else?
Any more questions from either counsel? I see none. Thank you both.
Right.
Go ahead, relax. What are you doing?
May it please the court.
Mr.
on-
Vogelsberg,
Yes.
I noted that on the prior discipline aggravator, that the panel mentioned there'd been a previous violation for candor to a tribunal. Do you know what that was involving? It was 2010, I think.
Yes. And I believe there was some evidence presented of the underlying facts for those rule violations at the hearing. My understanding is that Mr. Kepfield and a prosecutor in Reno County were litigating a case. The prosecutor asked for a continuance, and Mr. Kepfield alleged that he wasn't ready for trial, and that was why he was asking for a continuance. And so investigation subsequently proved that was not entirely accurate, and so
I'm sorry, who said they needed the continuance?
the prosecutor asked for a continuance, and I
Okay.
believe that the basis that he said for the continuance, Mr. Kepfield said was not accurate, said that he was not ready. In fact, the prosecutor wasn't ready for trial. The investigation of that complaint later proved that what Mr. Kepfield said was not correct, and so that supported the 3.3
But that was a
violation.
statement made to the judge,
It was.
not just to the
ju-
prosecutor? Okay.
It was the judge.
All right, thank you.
I'd just like to address the question that Judge Malone asked me about the results obtained for ES and EM. In paragraph 41, the panel did find that Mr. Kepfield had obtained good results for ES and EM. I think in connection to ES, I think Mr. Kepfield represented ES in his underlying criminal case, and I believe, as they mentioned, some of those convictions were overturned on appeal. And so that would be a positive result that he obtained for ES in his
Had
underlying
nothing to do with this
criminal case.
violation, but an earlier representation.
An earlier representation of
Okay.
him. And I would also say that Mr. Kepfield filed a brief for ES in the Court of Appeals that the Court of Appeals considered, and so at that very least, he obtained a positive result. He allowed ES to have appellate review of the previous denial of his post-conviction motion. In regards to EM, the good result would be Mr. Ketfield represented EM in both the criminal DUI and in the administrative suspension of the driver's license as a result of the DUI. And Mr. Ketfield in the criminal case filed a motion to suppress based on the fact that the initial traffic stop wasn't supported by reasonable suspicion. That suppression motion was denied. Mr. Ketfield filed the notice of appeal, did not represent EM on appeal, but that was an issue that they raised on appeal, whether or not the traffic stop was supported by reasonable suspicion. The Court of Appeals found that it was not and ended up reversing the DUI conviction. And so I would say that would be an example of Mr. Ketfield obtaining a positive result for EM.
Counsel, I need you to circle back to something you talked about in your first argument about your recommendation for indefinite suspension, and I sort of, maybe I wasn't listening as well as I should have. I was trying to bounce between the hearing panel's recommendation and your comments, and make the argument, I guess, to me again as to why the disciplinary administrator is at indefinite suspension when the panel's at basically 6 months hard time and then going back to probation.
I would argue that, again, the conduct at issue is serious. It occurred while Mr. Ketfield was on probation. It implicates dishonest conduct, which this court has said in several opinions that it's reluctant to grant probation when dishonest conduct is at issue. And again, I understand that the disciplinary administrator's office recommended disbarment at the hearing, and I'm recommending indefinite suspension now, and we're justifying that lower recommendation based on the fact that the hearing panel did not find as many rule violations as were alleged in the formal complaint and argued at the hearing.
I guess I'm questioning why, given the lack of candor, and I realize the repeat and all that, I mean, I understand the facts, but why isn't the panel's recommendation of basically 6 months suspension appropriate for the misconduct that we have in front of us, and then getting back to probation? See what I'm saying? I mean,
sure.
It's not their deal. I mean, they want to go back into probation, and I can see where a suspension is appropriate, but why isn't 6 months appropriate versus basically what could amount to 3 years plus when we get into the application for reinstatement and all
In
that?
this court's 2015 decision, the underlying suspension that was imposed was a 1-year suspension. So if the court is reluctant to grant indefinite suspension in this case, I think the baseline should be at least a 1 year, because that would recognize that Mr. Ketfield did not complete his probation, and so thus at least a 1-year suspension should be imposed in congruence with this court's 2015 decision. But I'd say at the very least it would need to be a 1-year suspension. I think also Mr. Ketfield presented evidence of suffering from anxiety and depression, and so if the court concludes that a definite period of suspension is appropriate, I would also recommend a 219 reinstatement hearing as well.
Any more questions?
What do we do with the argument that he's in a different place now, a different job, the responsibilities that triggered his problems no longer exist? Is that a consideration that for us is that after he violated the rules, violated his probation, he put himself into a different position when we have to, one of our considerations is the safety of the public, and it would seem to me that his not being in private practice or sole practice is a benefit to the public. So just
Sure.
address how we should factor that into our calculus.
I think if we do not have the rule violations that implicate a lack of the 8.1 violation, the 8.4 violation, then I think that the fact that he got the new job in the Public Defender's Office of Sedgwick County could be a consideration of maybe allowing probation and allow him to serve probation while serving in the Public Defender's Office. The problem is that you do have the lack of candor to the investigator when he indicated, yes, the funds went into a trust account, but then you ultimately don't have one. In fact, he didn't have a trust account between 2011 and August 2017. And so the fact that he was willing to lie about that, knowing that he was on probation and he had a duty to be candid to the investigator, indicates to me that probation would not be adequate in this case, even despite the fact that he has a new job with the Sedgwick County Public Defender's Office.
Any more questions? Thank you, counsel. Do you have any further presentation?
I do not, sir.
We thank all of you for your arguments this morning. The court will take this matter under advisement.